Good afternoon, everyone, and welcome to another CRED webinar brought to you by the Industrial Development Think Tank, which is hosted by CRED and supported by the Department of Trade, Industry and Competition. My name is Mondliwa, a senior researcher at CRED, and I will be your host for this afternoon. We have a great session planned for you today that tackles two broad questions. One, do the Competition Commission's buyer power guidelines go far enough in supporting small and medium enterprises as well as businesses owned by historically disadvantaged persons? And do they provide certainty for dominant firms in the designated sectors? The timing of the release of the guidelines is quite significant, and this is because SMEs are particularly hard hit by COVID-19 pandemic, and anti-competitive conduct can exacerbate their precarious positions, excluding them from effectively participating in the economy. On the other hand, dominant buyers may be re-looking at their supply chains, taking into account any key lessons they would have drawn from the pandemic period. And this means that they require clarity on the new provisions and guidance on what practices could be considered as contravening the amended Competition Act. We have a great panel of economic and legal experts who are at the forefront of these issues today, and in their capacities as practitioners and researchers in the competition space, they're going to help us to unpack these questions. I would firstly like to introduce Yongama Njisane. He is a principal economist at the Competition Commission and recently led the Grocery Retail Market Inquiry technical team. The inquiry looked at the functioning of competition in grocery retail as well as the constraints to the participation of small businesses. I think that makes him really the appropriate representative of the Commission, as I imagine he would have had to deal with exactly the types of issues that the buyer power guidelines are trying to address. We also have Shayzon Gaga. She is director at Acacia Economics, where she advises clients on competition and economic regulation matters appearing before South African and other African authorities. She is also a senior research fellow at CRED, where she has been working on questions related to digital markets. From the legal fraternity, we have Derrick Lawton. He is the co-head of the competition practice at Bowmans. He has been involved in prominent competition matters before competition authorities, both in South Africa and advising clients on competition law in various other countries around the world. He did say to me, I must mention that they've just opened an office in Malawi. So if you're from Malawi, Bowmans is now around. And last but not least, we have Fatima Fiandeiro. She is a partner in the competition and regulatory economics practice at Genesis Analytics. She has provided economic analysis in a number of cases that have come before the competition authorities and regulators. I'd like to welcome the panelists to the discussion this afternoon. Sure. Now, before we get started, just a few rules of engagement. First, how the session is going to run is that we're going to have initial inputs from the panelists, and this will be followed by a facilitated discussion with a few rounds of questions from the attendees. The questions should be asked through the Q&A function that you will see at the bottom of your screen. Given the large number of attendees, we unfortunately will not be allowing attendees to speak directly. However, please feel free to type your question into the box. And if you are addressing your question to a particular panelist, please indicate as much. There's an option to upvote questions. So if there's a question that's been asked that you're really interested in getting an answer to, please upvote this, as these are the questions that we're going to start the discussion with. And then just lastly, we're going to have a feedback poll that we're going to run right towards the end of the session. And we really do invite all the attendees to be able to participate in that poll. And now, without further ado, we are going to get started on the substance of the discussion for today. And I'd really like to start by bringing Yongama into the discussion. Yongi, the buyer power enforcement guidelines were published to provide guidance on the approach that the Commission will take in interpreting the new buyer power provisions, including how it will assess complaints and screen cases that it receives. Can you take us through the Commission's approach, and particularly I'd like you to address three things. That is, will the Commission assess dominance in these types of cases? And what is the thinking on what constitutes unfair prices and trading conditions? And lastly, how does the Commission intend on assessing whether or not dominant firms are avoiding or refusing to buy from suppliers that are SMEs or HTPs in order to circumvent the buyer power provisions? Yongama, you're on silent. Can you please unmute yourself?
All right. I suppose we're learning new meeting etiquette at this time. Good afternoon to everyone, and thanks for the invitation, Pam. I suppose by way of starting, these guidelines have really benefited from a lot of input that has been brought to the fore, both in the context of the development of the regulations themselves, right to the different, the different iterations of the guidelines that we've had. We've had substantial public comment and input that has really assisted to shape the document that we are discussing today. And perhaps just to give a broad overview of what the law says. The law essentially says that it is prohibited for a dominant buyer to either impose or require unfair prices or trading conditions from small businesses, what we typically call SMEs in South Africa, or businesses that are owned or operated by historically disadvantaged persons. We generally just use the term HDIs or HPIs, to characterize that group. And so, to your point, when we think about our enforcement approach, I think starting with dominance, which is the first question that you raise, we are of course guided by Section 7 of the Act, which sets out the legal test for dominance. But I suppose there's a slight difference here because we are now talking about purchasing markets. We start to think about this from the perspective of the seller. And I mean, you would have sure seen in the literature, they talk about the hypothetical monopsony test. It's kind of the guiding principle that we would be thinking about here. Of course, I mean, the law itself is quite clear that there's presumptive dominance for firms that have 45%. But I think where we're talking about firms that we're sitting at about 35% or less, and so we start thinking about questions of market power. This is where I think the scope of the inquiry and the thinking is quite important, because within that context, as I've already mentioned, and I mean, a lot of what we consider there is very much interlinked with what you would consider in the context of market definition, I suppose, where we're starting to think about the narrowest possible markets that we are looking at. And within that context, we are thinking about what are the outside options that are available to the sellers. What are the alternative distribution channels that we would be looking at? And here, of course, I mean, we are looking for distribution channels or alternative buyers that would be sufficient outlets in order to offset the volumes that the seller would not be able to sell to the dominant buyer by virtue of that exertion of market power. We're also thinking about a number of other things. Of course, market structure is also another important element to consider, that because it does have implications around the bargaining dynamics that you see. One of the things that we saw in the retail market inquiry, for an example, and we make this point when we think about bargaining power or buyer power within the context of the South African grocery retail market, we make the point that the structure of the South African grocery retail grocery sector in this country naturally lends itself to a distortion in terms of the bargaining dynamics that you see within that space. We also start to think about So the broader issues around supplier dependency on a particular buyer or on a particular channel. We also think about outside options, as I've already mentioned, but also we think about this also in the context of the buyer itself as well. And another element that we consider here, which is also quite informative, is just the nature of the bargaining or the nature of the negotiations themselves, which are quite a useful thing to kind of be able to draw inferences around the bargaining dynamic that is at play between the buyers and the sellers. So that's kind of the broader set of thinking around what we would be looking at in terms of dominance. And then when we talk about the characterization of the conduct itself, and here we start talking about, so there are two broad categories, of course. We talk about unfair pricing, and we also talk about unfair trading conditions. So briefly, just on unfair prices, there are two broad categories that we're thinking about in terms of unfair prices. First, we think we have a category which is essentially relating to scenarios where the price that is paid to the SMEs or HDIs is lower than that which is paid to other suppliers of similar goods or services. The second category is in a situation where the price that is paid to the SMME or group of SMMEs and HDIs is lower than that which was previously paid to the very same set of firms. And just to give a little bit of detail there, on the first category, this is where we're in a world of thinking about material differences. I think that's the first important thing to emphasize. We're looking for material differences between the different groups and whether there's an objective justification for the differences that are observed. And so this is the, if you look, I mean, I think it starts on around page 14 or so, where we lay out some of the factors that the Commission would think about in terms of what would constitute, what would we think about when we're thinking about material differences? What would we be thinking about when we're saying that, there's an objective justification or not? And when you think about the second category, which is where there's a downward revision in the price that was previously paid to the same supplier or group of suppliers, here we are thinking about two things. One, there could be a direct reduction in the price. But in some other instances, you may have a situation where the buyer is able to impose on that supplier or group of suppliers additional costs that would essentially have the same effect. So costs that would effectively result in a reduction in the net price that is paid. I think the retail sector, again, is a nice example here. If you think about the context, and I'm not saying that I'm not saying that there's anything to draw from this, but when you think about the practice of rebates, for example, the different cost elements that would be required from suppliers, and how that would essentially have the effect of reducing the net prices that you are thinking about or that you are looking at. So that's what we're thinking about when we're talking about prices. When we talk about unfair trading conditions, I think here the broader principle here is looking at conduct that would have the effect of unjustifiably transferring risk or costs from the buyer to the seller or to the group of sellers. And I think this is a well-established principle. It's a principle that we see quite a lot in other jurisdictions as well. If you think about the UK, I think the EU has also established this principle quite well. And so the question is really whether those conditions, those trading conditions, unfairly transfer risk or costs to the designated supplier or group of suppliers. And part of the thinking is whether these trading conditions are either onerous, are they unilaterally imposed, for an example, and whether they are not proportional to the objective of that particular clause within the contract. So an example that comes through in the guidelines is an example of payment terms, for example. the period within which suppliers may be paid. And there's an interesting example. If you look at the Kenyan experience within the milk industry, there was an issue around power, which was premised on this very point, that the retailers within the Kenyan retail market would impose quite long and unduly long payment periods to the suppliers of milk products. And in particular, when you're thinking about fresh milk, I think there was a period of about 90 days or so for the payment of fresh milk, and how this had an impact on the ability of small players to be able to sustain themselves in those markets. So that's kind of the broader thinking around the characterization of the conduct. And as one thing I didn't mention when I was just describing the law is that there's this avoidance provision that has been put in the law, which is basically trying to circumvent circumvent a possibility where dominant buyers may try to overcome the operation of this particular part of the law by avoiding to deal with small businesses or the designated class of suppliers. And so what that provision basically says is that dominant buyers cannot, as a means of trying to circumvent the operation of this particular element of the law, refuse to engage or to deal with with SMEs or HDIs. And I mean, we'll probably just call it the avoidance provision. And so there's an interesting question, of course, around, which is what you asked. How do we then determine that a firm has unfairly or unjustifiably decided to not deal with SMEs or HDIs? And I think here, a lot of this will be drawn, out of inferences. I think there's a lot of value judgment that will be made when you're thinking about the assessment of the evidence that will come before the commission. Because first of all, you want to determine whether factually there has been an avoidance or a refusal to engage or to deal, and whether, and I think this is the key element, whether what is the rationale for that refusal, and whether that rationale is objectively justified. I think this, at least on our thinking about it, this is kind of the broader set of the inquiry. And so here we may think about a number of things. And one of the things that I think have popped up over time is you might have instances where firms do not necessarily directly refuse to engage, but they may constructively, we tend to use the term constructive refusal to deal. And here, this is where we're thinking about, for an example, whether the requirements that have been set for the suppliers by the dominant firm are such that you constructively remove that group of suppliers from being able to participate and supply goods and services, and whether and so the question is whether this is in and of itself essentially presents a kind of an unjustified constructive refusal to deal. We may look at things like what's the firm's procurement strategy in general, and how that informs the manner in which it engages with SMEs and HDIs. And so we would make these inferences based on the available evidence. But of course, I think if you have a firm, for an example, that has a history, or generally that generally does not deal with SMEs, I think those are kind of low-hanging fruits in terms of being able to kind of quite early on be able to determine that we may have some areas of concern, or we should have some concern in the manner in which that particular firm conducts itself. Perhaps if I think I might just stop there because I've been going on for a while.
Thanks, Yongama. I think that's a useful way of outlining the Commission's approach, and the examples that you've given, particularly around the grocery retail examples, I think are useful to kind of help people think through the issues. Sha'ista, you've done a lot of work in e-commerce, so I'd like you to bring in, and so you can bring some reflections from that perspective, as e-commerce is one of the designated sectors. And I mean, we've seen several international competition cases as well as market reviews that have considered the market power digital platforms. And one of the consideration has been the implications of the exertion of buyer power on suppliers by e-commerce platforms. So from looking at the guidelines, are there any issues that have been raised in these cases and reviews that you do not see being reflected in the kind of guidance that's been provided by the Commission?
Thanks for inviting me. As you say, in recent years, one of the more exciting developments in the competition jurisprudence has been digital platforms and the market power that they've exerted. We've seen in many countries there's been enforcement activity against some of the big platforms. And there's also been a lot of policy discussion. So for example, there's the Stigler report that has emerged in the US, there's the CMA report in the UK. And a lot of these have sort of tried to think about how we would regulate these platforms that are a bit different in terms of the economics. I think in South Africa, we have an industry that in many aspects is more nascent in some of these areas. But with COVID-19 and the changes in the environment, I think it's become a more important route to market for a lot of SMEs. So one concern that's arisen in numerous countries has been the vertical issues. And I think the key one that sort of stands out is just relating to the dual role that some of the larger e-commerce platforms have, both as a marketplace which has third-party providers and a distributor which themselves sell products to customers, and the discrepancy sometimes in the treatment of these third parties versus their own. So countries have addressed this differently. We've had the EC, which started a competition case against Amazon. Others, such as India, have used other tools. India has created a vertical unbundling of Amazon and its other large platforms using foreign direct investment legislation. So in the South African context, what's interesting is that we're using a different tool. And in doing these guidelines, we're creating a sort of softer means of shaping the market when it's still quite young in some ways. So trying to put in pro-competitive regulations. When I look at these regulations, I think they cover all the key areas that have emerged internationally. This ranges from using supplier data for a platform to be able to enhance its own products relative to suppliers, the most favored nation clauses and other clauses that emerged in cases such as booking.com. There's issues of self-preferencing and paying for higher rankings, which emerged in the UK. So if you sort of look at the range of cases, it seems like these guidelines cover a lot of it. But that said, there are a few points that I want to raise, which is probably a bit broader than the guidelines themselves. I think firstly, there's a question as to whether this protection is full enough in some ways, or whether it's partial protection. Because when you look at other countries, which are sort of looking at digital regulators, these policies are broad, whereas here it's sort of quite restricted in that it's under a dominance provision and it only applies to SME and HDI companies. So I mean, that's good because you're protecting your most vulnerable groups. But at the same time, in a changing and very dynamic market, is it going to provide sufficient protection for other companies in the digital realm? So for example, bricks and mortar companies who at some stage want to access what is a must-have online channel, are they given sufficient protection? So I think it's a good starting point, but maybe there's a bit of a gap in coverage in the long run. The second one is quite a broad policy thing. And it's just that competition is one part of digital regulation, and it operates with trade law, it operates with privacy protections and consumer protection. And I think one of my concerns is that they intersect in numerous ways. So for example, the guidelines prevent using supplier data to improve your offering, but at the same time, a question for suppliers would be access to consumer data. Now, the question about whether a platform needs to provide its suppliers with consumer data on how they shop impacts on their ability to compete, but at the same time, it's impacted by privacy considerations and other laws. So I think there's a very strong intersection between consumer protection and privacy in the digital space, which is going to be impacted. And while this covers a lot of it covers the supplier issues, there's the consumer issues, which the Competition Commission basically doesn't have the authority to sort of focus on too much. So you sort of end up with a bit of a regulatory patchwork. I think, I mean, I'd like to be a bit controversial and say, on a broader perspective, should there be a separate competition authority and consumer authority? Or is the intersection between consumer and competition issues so much that we actually require one authority with a mandate over both, particularly in areas such as digital and with sort of considerations such as the role of data in sort of both as an individual's privacy and as well as impacting on supply chains and competitiveness. So that's my second consideration. The third is with the current legislation, there's anti-avoidance mechanisms in the Act. But I am a bit concerned that in an industry that's still developing, where there's sort of less of a standard of how things are, it could create some avoidance in how business models are developed. So if we don't look at it as a static view, as people not avoiding small retailers they currently engage with, but how companies that are innovating set up their market models in the first place. And whether for a company that currently provides a way, I mean, if we stop for a second and just look at e-commerce, the fact that many large platforms have third-party providers is a great route to market for SMEs. You have your creative individual that creates some type of niche product, and the fact that they can put it on an Amazon or a Takealot is a route to market for them that they wouldn't have accessed ordinarily. So it's something that has a great role in enhancing SMEs. So the question is, if it becomes too onerous to deal with SMEs, would companies have an incentive to avoid providing that option and rather go for a purchase and on-sale option? So I think one of my concerns then is that if you look at it in other markets, I mean, we interviewed as part of the CCRED projects manufacturers in China, and they had noted that whereas they had originally sold products through Amazon, as time passed, Amazon would increasingly directly contract with them to produce the products and sell it under the Amazon label. So there's a question as to whether creating too many barriers actually would take away some of the routes to market for SMEs and rather create large companies that just on-sell. So that's sort of like a long-term dynamic perspective. So though we have the anti-avoidance mechanism, the question is, how does that impact the long-run incentives? And also, in people getting on, is there access and transparency around the conditions for listing, conditions for access, so that SMEs that don't get on have a sense of why, rather than just sort of not understanding exactly what the dynamic is? And I'm going to stop here as well.
Sure, thank you, Sha'ista. I mean, I think those are very useful inputs, especially raising issues that would come up from the perspective of potential complainants to this new provision. I'm now going to turn to Derrick, and we'll pick up on some of those issues, Sha'ista, later on during the discussion. I'm now going to turn on to Derrick to provide his initial inputs, and I'd like you, Derrick, to really kind of focus on the question of to what extent do the guidelines provide certainty for firms? And in your response, I'd like you to touch on three things. One being, does the nuance that has been added to the assessment of dominance provide clarity for the types of firms that the Commission would be pursuing under this provision? Does also the guidance on the assessment of avoidance provision clarify the steps that a firm would have to take to ensure compliance? And then lastly, would a prima facie case established by the Commission as outlined in the guidelines be sufficient for a firm to get interim relief endorsed by the Competition Tribunal in terms of Section 59 of the Competition Act?
And well, thanks very much for the opportunity to participate in this, and it's a real privilege to be able to do so. What I thought I would do is just to kick off with reminding those who need to be, what we're talking about here. The three elements of the law that need to be kept in mind is the section itself, Section 4, which has the prohibition along with the anti-avoidance provisions in Section 4.1b, and then obviously in Section 4c, the provisions which change the burden, the evidential burden. So once the Commission's been able to present a prima facie case, then the dominant firm concerned needs to justify why the terms on which they procure are not unfair insofar as price is concerned and insofar as the terms and conditions are concerned. And that's what the law says. What also needs to be read with that are the regulations that have been published by the Minister, and then obviously the Commission's recently published guidelines, which are not law, but are very instructive in giving some guidance as to what dominant firms need to think about when they are engaging with these provisions. And I suppose it's in that context where the context of this needs to be kept in mind. This is not like other similar provisions in other parts of the world, something of general application. It applies to designated sectors and to designated groups. They are SMEs and HDP firms. And that has so happened, I had the privilege of being involved in the NEDLAC process, and those who've read the documents, white papers leading up to the legislation itself, will see that this is there to address a key policy imperative in South Africa. And that is to address the racially skewed nature of our economy and the concentrated nature of our economy in many sectors, including those which have been designated, that inhibit the ability of small players and black-owned firms to come into the market. That's the issue that is being focused upon and what is being addressed. And so the first thing I've been saying to clients is, you're not dealing here, consistent with what the guidelines say to you, a broad application. It's very, very specifically addressed. And that's the important thing that needs to be kept in mind. And so far as the guidelines are concerned, I mean, I read them with interest as over this weekend in preparing for this presentation. And I'm sure economists might be able to put it better than I can. But when you're talking about NOPSONY, purchasing power, all of those, I read these, especially insofar as the guidelines deal with market power and referencing, 15% purchasing ability within a market, that ultimately it seems to be introducing into our law a relational dominance question, not dissimilar to what I know the Commission argued in some of the recent excessive pricing / price gouging cases, where a relational element must be taken into account when assessing market power, by virtue of the pandemic and the crisis which applies in South Africa, and how those circumstances can impact somebody's relational position with respect to a purchaser of those products. And that, I think, is something we're going to have to get our heads around and to understand, and something that the guidelines go some way to help us to understand, but still, I think, something where more the tribunal and the Competition Appeal Court will have to give some more thought with respect to. But I suppose grappling with these issues is not something that's new to South Africa. And frankly, if you read some of the literature around the world at the moment, there's a big debate going on around what structural antitrust interventions need to be undertaken in order to address long-term competition concerns and welfare outcomes for society. Big questions are being raised around whether or not the historical consumer welfare test is really the one that does the trick, and should we not now be focusing on other levels of the supply chain, as this legislation does, to address broader policy imperatives. And if you go back to the Nationwide case, and I know the Nationwide polls case dealt with price discrimination, which frankly is the flip side of the market, the downstream flip side of the market to what we're dealing with here. But even in that case, the tribunal in particular said that there is ultimately this balance between addressing public interest outcomes and addressing consumer welfare outcomes. And there, I suppose it's important to say that that the guidelines in particular, not so much the regulations nor the act, say that that's something that may not be relevant to the assessment. It ultimately is a fairness assessment, and one which must be considered in that context. And Yongama will correct me, but I suppose implicit in that is that these provisions and the Commission's guidelines say that there is going to be an expense here for consumer welfare, but it's there to address the policy imperatives reflected in the legislation and the objectives of the Act. And so finally, what we've been saying to our clients when trying to advise and prepare them for this legislation is that you can no longer be agnostic about who you buy from and who you supply to. You need to think about who are the groups that make up your customers and suppliers. And in circumstances where even the guidelines recognize that you're not compelled to buy from anybody who's an SME or HDP firm, and you're not, you are nonetheless required, I would think, to do an exercise as to who makes up those groupings, such that if the commission comes through the door, you have an appropriate narrative and justification to say that you do have appropriate members of those groups that are your suppliers, so as to meet the claim by the commission and to the extent necessary meet your evidential burden. But I do think, as a last point, be that with respect to interim relief or otherwise, Pam, there's going to be a lot of dispute, unfortunately, I still think, around how this should be interpreted, whether and under what circumstances the Commission's met its prima facie case, and whether it's correct to say that this is an assessment which does not entail an effects or similar consequence type assessment, at least with respect to the justifications, and in fact whether the assessment being undertaken by the Commission is there to achieve the objectives of the Act. And I just want to pick up on one point Shayista made, and that is, this is part of a number of mechanisms that must be undertaken. This is just a part of what policy imperatives are to address these issues. And I couldn't agree with Shayista more. This peculiar difference between the Consumer Protection Commission and the Competition Commission is just a waste. They should be together because what they're trying to achieve actually dovetail in many respects. I hope I've covered your points there, Pam. I'll stop. I think my time is up.
Thanks for that, Derrick. I think you've covered a number of my points, and I will bring the other panelists in on some of the points that you've raised. But I think first we'd like to hear from Fatima. And Fatima, we've seen the analysis of buyer power in competition law has gained increasing attention in recent years, and this is both from competition authorities as well as in academia, and this is not just in South Africa but internationally. What are the key economic debates in the literature and jurisprudence relating to assessment dominance and the standards for assessing the exertion of buyer power, and to what extent do the guidelines take these debates into account?
Thanks very much, Pam, and good afternoon to everyone. It's a pleasure to be on this panel discussion. So Pamela, the two issues that you raised really around dominance and the test for assessing unfair pricing or trading conditions, you know, for me are very key questions now that we have to grapple with as these provisions come into effect. I thought it might be useful to frame this and to think about it from the perspective of an economics practitioner who would have to engage with this, and also particularly in trying to give guidance to businesses when they are looking to comply with these provisions. And I think this is consistent with your overall theme about whether or not these guidelines provide, you know, greater certainty for businesses in their compliance program. And so hopefully in answering that way, I answer the questions that you've raised now too. So starting with dominance, as Derrick already mentioned, you know, this is a necessary first step. And in fact, you know, since this falls under Section 8 abuse, they have to be found to be dominant. And I think this is where there are some very big, interesting debates, and Derrick already really started going into some of them around the question of relational dominance. So before going into the broader debates, I think it might be useful just to frame how the Commission has sought to provide guidance now. Yongama obviously did a very good job capturing all the very elements that we consider. And indeed, it would consider Section 7 and the market share thresholds, where there would be a presumption of dominance, where shares are over 35% in the purchasing market that is defined. But then critically, as Yongama took us through, there's almost two other elements. First, they are clear that the guidelines are clear that the assessment of dominance will also consider shares that are significantly below 35%, but still a material share, but also that there would be a list of other factors that it would consider in determining market power. You know, these include things like supplier dependency, outside options, as well as alternatives to the buyer, because this makes sense, because if there are many outside options to the buyer, then the ability to switch would give them some form of price, some ability to negotiate price. It will also consider the nature of the supply negotiations, and again, how this might be compared to buyers that are outside of this, of the designating class. So I think by explicitly introducing these elements, this suggests that it may be possible for a firm to be identified as possessing kind of market power with respect to a particular class of suppliers where they might not have a high market share. And that might be a fair point, because, you know, these thresholds, I think, were often contemplated from the perspective of a seller's side of the market. And it might make sense that suppliers have less outside options. But I think more interestingly, and this really goes to the point that Derrick raised, it also might suggest that a firm might be found to have buyer power in the sense of you know, market power, where it wouldn't really be considered in the traditional or classic sense, where you have market power for the market as a whole. And so I'll explain that a bit more. You know, so when we look at the literature, it is indeed the case that buyer power is often not expressed in the classical sense of market power, but often more in the form of bargaining power that is exercised bilaterally relative to individual suppliers. You know, however, I think the difficulty, you know, I have as an economist is that these are not necessarily the same from an economics perspective. Market dominance does not simply equate to an imbalance in bilateral power relationships. And so when we think of a traditional sense of buyer power, they would have to be able to almost dictate terms for the industry as a whole. But what we see here, and what the Commission is really, I think, signaling, is something else. So a group of suppliers could be heavily dependent on a certain buyer, but that would not necessarily mean that they have substantial buyer power. And so, for example, you know, small suppliers might rely on just one buyer for almost all of its sales and be economically dependent on that buyer, and therefore have quite a weak bargaining position. However, there might still be other suppliers of similar products that have greater bargaining strength, such that the buyer doesn't have substantial buyer power in the relevant market. And because of this tension, we actually see that similar considerations has meant that elsewhere they've often thought of this as an issue around economic dependence. And this is why other jurisdictions have either sought to carve out a separate provision for economic dependence, or not really prosecute unfair purchasing practices under competition rules. But of course, I think, to be fair, this doesn't mean that there's no relationship between the concepts. And of course, the starting point, as Yongama took us through, you know, for market definition is to identify alternative buyers or distribution channels that are available for supplies in the SNP test. And, you know, I suspect that what we might see is there'll be narrow markets defined around a set of suppliers that might have fewer outside options. And so I think this would be a large area of contestation going forward with enforcement. And I suppose, you know, for me, ultimately, I have a question, and it's useful to have Yongama here, as to whether, you know, this ultimately lowers the requirements down to the level of relative market power or dependence. However, going back to the compliance perspective, Pamela, and the question you originally asked is whether this provides certainty. Now, I think for me, the guidelines at least make it clear that large firms in these designated sectors need to think quite carefully as to whether or not they would be considered to be dominant, especially if indeed there is a lower bar. And so firms wishing to comply need to think about this quite carefully. So for example, Yongama mentioned, the supermarket chains, which would be covered, whilst I think all the supermarket chains are important for supplies as a route to market, especially because of the scale of purchases, it's far from clear that in a traditional or classical sense that would be dominant. But the guidelines seem to be suggesting, thinking about it in a different way. And so I think from a compliance perspective, the guidelines are being quite clear that you have to think about this quite carefully and have probably a more nuanced view as to what market power means in the context of purchasing markets. Maybe then just to quickly go on to, if that's okay, Pamela, onto the second.
1 minute.
Okay, 1 minute. Just the test for unfair pricing. And I haven't really gone there yet, but I think, as economists, we do grapple with this problem, and it's quite hard to almost pin down what an unfair price is from a purchasing side. And, in particular, the costs of production will differ amongst firms. And so some might be more efficient than others. And so a low price is okay for them. And also from the compliance perspective, we know that the dominant buyers do not have access to, the cost data, for example, of their suppliers. And yeah, I would say that the guidelines provide some really useful benchmarks for thinking about it. I won't repeat what Yongama said. It really is about comparisons as well as about whether there's been a decline. And I think, comparisons make sense. And if we start any kind of compliance exercise, it would be a starting point. And to go to Derrick's point, it really gets at the heart of what this is looking at, which is really unequal bargaining power, which is used to impose prices or trade in terms that wouldn't apply to larger suppliers with more equal bargaining power. So I'll finish there, I think, as a general sense, and just to point that I think in that instance, the guidelines certainly are very helpful in providing more certainty as to what would be a low price, which is intrinsically quite hard to unpack in this context.
Sure, thank you so much for that, Fatima. I think those are very useful inputs. I'd like to remind everyone to please type in their questions to the panelists. But before we go to the attendees' questions, I have a few questions where I'd like to bring the other panelists in on points made by others. Yongama, Derrick made a point earlier about how the guidelines are representing a move away from the consumer welfare standard. I wanted to know from the Commission's perspective, would you agree with this, or has the Commission been looking at not just the consumer welfare over the years?
Be nice to me, Yongama.
Yongama, please unmute yourself again. Yeah, great.
All right, I'm clearly failing very dismally at this. But I mean, I think from our perspective, I suppose the law, in the way it has always been crafted, has always been much more broader. In its conceptualization around the standard itself. And of course, in practice, we've generally used, the consumer welfare standard. But if you think about it, the law has public interest, and that has always been clearly encapsulated in the law. And I think, as Derrick correctly pointed out early on, around just the policy objectives around these provisions, I suppose it is an extension of a standard that was previously not necessarily within the context of abuse, and just moving it into abuse of dominance considerations. But also, I do think that because if you look at the biopower provisions, I think South Africa is being very intentional and very explicit about how it thinks about the treatment of small businesses broadly, or HTIs broadly, and that in and of itself, if you think about it, so the way we are thinking about it is that there certainly is a business case to be made for the inclusion of small businesses, and I think this is a global thing around the importance of small businesses in markets in general. And that is an important thing because, of course, when you think about innovation, when you think about dynamism in markets, and most importantly, thinking about consumer choice and variety of goods and services that are available to consumers in markets, from where we sit, this essentially fits in within that context. And so it is not necessarily an altogether shifting away from a consumer welfare standard, because choice does matter as part of that matrix of consumer welfare considerations or outcomes. Choice is also an important part of that. And that, I think, comes in also within the context of having small firms that are able to not just be in these markets, but are able to effectively participate. They are there, they are able to get into these markets and grow and transition into effective competitors in these markets. And so I think it's just that relation, the way, that's how we think about it, if I may.
Sure. Thanks for that, Yongama. Fatima, I see you wanted to add to the point.
I just wanted to add, I suppose, that I think, and the way, Derrick contextualized this, that this has a very specific meaning in the Act and almost a specific place. So, from my perspective, this hasn't necessarily meant that we've thrown away the consumer welfare standard, because that still applies. And nor does it mean that the consumer welfare standard has been reduced to allow for this. There was a reason why this provision is separate under 8.4D, where you actually don't have a balancing of effects. And I think that's exactly right, because the concern here is a public interest concern, as Yongama mentioned, which is what they're seeking to address, and not really something that has considerations from a consumer welfare perspective.
Sure. I think I'm going to start taking the questions from the attendees so that we can maximize people's participation in the time that we have left. Shayzon, perhaps you can start us off on the first question, which has been upvoted. Would trade conditions include private standards as well? I think this occurs a lot in grocery retail, but I imagine it's also something that happens in e-commerce markets.
Hi, Pam. Sorry, I'm just having some technical. Okay, I'm back on. Sorry, I just lost the page for a second, and I was trying to look for the question. Could you just? Oh, would trade conditions include private standards as well? I'm not sure. I'm not sure. I actually don't want to. I would assume that it would include certain private standards as well, but I actually, I didn't think about this enough to sort of answer this question. Sorry.
Sure. I think Yongama, could you come in there? I think having done the grocery market retail inquiry, I know private standards are a real big issue when it comes to supermarkets. And in fact, I think this links quite well with the next question that's been voted around constructive refusal to deal. And I know in some circumstances it has been considered that the private standards are sometimes, in particular contexts, a constructive refusal to deal with smaller players. Would you be able to comment on that?
I think the framing of the provision itself is broadly defined, right, when we talk about trading conditions in general. And so I suppose not being a legal practitioner, and maybe Derrick might be much more useful in this context, but I do think that they probably might be included in there. And of course, I think it's important to bear in mind, though, that the key issue really is not whether the private standards have been imposed, it's whether they are unfair or not. I think that's the critical question that we are asking. And so I think broadly, you are probably you are looking at a world where they will be in as well.
Sure, and maybe just to follow up on that, and Derrick and Fatima, please come in response to this question. It's been argued that the same standard that is applied to suppliers of different size, right, can have different impacts on the suppliers. So if you have a requirement, for instance, that payment takes place in 90 days, a big player a big supplier that has sufficient cash flow, this might not be a crisis, but a small player that doesn't have the same level of cash flow, it might create a crisis for that particular business. I mean, how do you see the Commission engaging with those kinds of trading conditions that are quite common in a lot of contracts?
I mean, I can take a step. I mean, I suppose to answer the first question regarding private standards, and I hope that I understand the question correctly, but the answer is yes, this is going to apply to all private relationships, contractual relationships between persons that have differing personal rights. So yeah, it really is applicable to those types of private relationships because they involve engagements between different parties. Insofar as constructive evidence of constructive endeavors regarding these provisions, that's a very good question. I haven't thought it through properly, but I suppose parallels would be drawn with the labor legislation in South Africa regarding constructive dismissal. In other words, conduct which is not express, but effectively which makes a circumstance so untenable that somebody can't contract in a particular way is what will be looked at. Insofar as some of the other questions, I mean, what I found quite interesting to read were the annexures to the guidelines, which set out in quite a lot of detail. I think if my memory serves me, there's Annexure 2 and Annexure 3. Annexure 3 deals with e-commerce and those types of engagements. But they are very, very clear as to what types of provisions or conduct may, on the face of it, be unfair. And many of those, and we can debate it, are quite common provisions. One of the big issues I think that has played out, if you read about things in the press, where small businesses, businesses trying to get up and running, complain about the time it takes to get paid because that really impacts their cash flow. So the first item that's on the list there, if my memory serves me correctly, is payments beyond 30 days are seen as indicative of being unfair. Now that's very, very common. I wish some of my clients would pay me within 30 days. But there are a whole list of things. And I think that if there's one element of that you probably want to read of those guidelines, it's those provisions which are indicative. And my reading of that is that, volume differences, if anything, will fall to the dominant buyer to justify. And there may well be some type of justification attached to that, but I don't read the guidelines as saying that's determinative. I mean, look, I've made the point. Let me not talk too much longer. I hope that made some sense.
Yes, no.
Just tag on, I think it's exactly what Derrick says. The guidelines are actually very, whilst they're clear that this is not an exhaustive list, it provides a lot of clarity as to what would be considered an unfair trading condition. And interestingly so, it doesn't have to be applied differently between larger firms and smaller firms. So if you are a buyer with market power and you adhere to and you engage in some of these practices, it doesn't matter that you actually also do it to larger firms, because here the test is not really a comparative one, but one where very specific areas have been laid out.
Sure. Another question that is quite popular is by Rina Desnaya. She's asking to any of the panelists, is there a risk that the new regulations might disincentivize beneficial relationships between suppliers and buyers? For instance, supply development programs between retailers and suppliers. Yongama, could I draw you into that question? I know the guidelines had a frequently asked questions that covered this in part, and then the other panelists, please come in if you have anything to add.
I mean, from our perspective, certainly we don't think that they should, or they will, or are likely to disincentivize these supply development programs, because I suppose, as I've already mentioned, I mean, the whole idea around the regulations and the guidelines themselves, it's about what the kind of treatment that is not favorable towards a particular class. And here you will find, I mean, I think by their very nature, most of the supply development programs are generally geared towards diversification of the supply chain for most of these businesses. They are certainly targeting, it is the kind of favorable treatment actually you want, in other words. And so we certainly don't think that they're likely to disincentivize these programs.
Sure. Just a quick question before I bring in the other panelists. What about if the supplier development program is not all inclusive, but quite selective in terms of it's selecting 2 or 3 small suppliers and there are other, smaller suppliers? How do firms deal with that kind of situation?
I mean, I think that the question is about, rationality and the rationale and the objective justification. So if you recall, we talked about this earlier on, which was about what is the justification for the treatment or the differences or the manner in which the firm has conducted itself, and whether that justification is objective in essence. And so when you have a scenario such as the one that you've just mentioned, where in large part what you're seeing are larger suppliers and very few small firms, I suppose the question to ask is whether there's an objective reasoning why we are seeing fewer smaller firms that are part of that program or not.
Is there, Derrick?
Yeah, I'm happy to add to that. I think that's very interesting. I mean, just going through the chronology of this legislation, and I'm talking from memory, I suppose one of the concerns that did arise was, with the provision itself, which is now Section 4.1a, disincentivize certain economic outcomes. And that's probably what was the catalyst for the anti-avoidance provisions that were introduced. But I suppose there is this underlying concern regarding incentives. I did read with an element of surprise the guidelines where it made reference to enterprise development programs in terms of the empowerment legislation. And I haven't thought about how this will exactly fit in to that legislation, but my encouragement would be to the Commission to change that, because I think there might be some real strong dovetailing between the empowerment legislation and the rewards of that legislation to enterprise development programs and the outcome wanted to be achieved by this legislation. So I think there's actually a scope for dovetailing. How that's all quantified is beyond what I understand at this stage, but I think that's conceptually what those programs are intended to achieve. But at the heart of it, it means that dominant firms' purchases are now going to have to pass rents up the chain. And I think we debated it yesterday as we were preparing. When I did economics years and years ago, everybody told me that the higher up the supply chain you are, the more likely you have market power. It's just shown to be absolutely wrong, because we see, especially in South Africa, where bargaining power sits below, further down the supply chain, that's not what's occurred. But ultimately, this is intended to ensure that the lack of bargaining position of certain suppliers is enhanced and so that their margins, rents, accrue higher up the supply chain. That's what's intended to achieve. That should be quantifiable in some fashion, and it should be something that accrues within an enterprise development program, I would think. But just to emphasize the point, this is at the heart of the guidelines in my reading of it is bargaining positions and the lack of bargaining positions that exist at certain levels. And in that context, what really matters is price and the net effective price as highlighted in the guidelines, along with costs and risk and retrospective or immediate application of those. And if you're thinking about what your terms of contract are with SMEs and HTP firms is in that context and comparing it to other firms that have better bargaining position, what are the differences and what is the magnitude of those? I mean, I did see with interest the Commission's reference to a 3% screening criteria, which I found to be quite interesting. And Yongama, I wouldn't mind getting your thinking around that later on in the conversation. But that's essentially what should be thought about in my mind when you're trying to see how you as a dominant firm, dominant purchaser, makes the comparisons to justify what differences there may be and why they may be appropriate.
Well, thanks for that, Derrick. I think let's take the next question from Tammy Simon. She's asking, does the designated sector, grocery, wholesale, and retail, apply to retailers who sell grocery type products like food, drinks, toiletries, etc., without being general dealers or grocery retailers? Any takers for that particular question?
Okay.
Go ahead, please.
All right. I mean, I think, of course, the primary focus, if you think about grocery retail, so the primary focus naturally lends itself to grocery retailers or wholesalers or general dealers. But I'm not quite sure if that would exempt those kind of firms that may sell food, food-related products or food products. And so I think there's a kind of a broader application, and I suppose the way we've always kind of tried to conceptualize or define grocery retailing and wholesaling or food markets in this country generally has always been kind of a much more broader spectrum, and I think that also as a result of the way that the sector itself has evolved over time, and what we are seeing, of course, and with the developments that we are seeing in the digital space, probably it gets a bit even more trickier to draw the lines and say these particular firms are in and certain others are not. I think we're not in that world where it's clear. I think broad, in my perspective, I think there's kind of a very broad application here.
Sure. There's a question for Sha'ista, which is asking, Sha'ista, can you please share emerging issues regarding e-commerce platforms and supplier engagements? I mean, the question's quite broad, so if maybe you can make one or two inputs that's relevant for this discussion, Sha'ista.
Okay. I think the emerging issues around supplier engagements, I'm going to sort of draw on what's happened internationally more than in South Africa. But often with suppliers on e-commerce platforms, you end up having a large or must-have dominant supplier, and then suppliers that provide their products on that platform are sort of price takers. So a lot of the emerging things, one relates to access to the platform, to the delivery system, and who's sort of allowed onto that platform or not. The second relates to access to data. So data is a currency by which a company can understand and plan for the future, and access to that data from consumers on the platform or suppliers' data, so sort of seeing which products sell well or not. Platforms have often used that data to then develop their own strategies. So that's become a key source of tension between suppliers and platforms. So data as a second big issue. And then other issues that have arisen are contractual terms between suppliers and platforms. So this might include, for example, requirements that a supplier doesn't offer their product for a lower price on any other platform, including sometimes their physical stores or directly maybe a hotel on their own website versus another one. So that's been another issue where the supplier sort of creates a lack of competition generally in the market between different types of platforms. So those are some of the key ones that have arisen. But I guess it's sort of like, while some of the issues are pure vertical issues, it's a supplier that's on the wholesale level and the retail level and provides its own retail arm almost with better terms and conditions than third-party suppliers on the platform. So it's sort of a combination of some issues such as the data, which is specific to digital, but also some of your classic vertical supply issues. Yeah, so I don't know if that helps with some of the issues.
Yeah, I think that that covers it. Maybe one of the last questions that we're going to take, this is for Fatima. Would you therefore, I think this is building on the points that you were making earlier, would you therefore agree that having a superior bargaining position would result in buyer power without a firm having a dominant position as such?
Well, you know, I think at the heart of these regulations and this provision is really to prevent the unequal bargaining power which exists. And, you know, as Derrick said, often you think of it being concentrated at the upstream level, whereas what we see in some narrower market contexts like value chains for food, you know, downstream is more concentrated than upstream. And so in that sense, there is you know, fewer options for a seller to sell into. And so, you know, I understand why a lot of the guidance goes to issues around bargaining power, because that is actually what goes to the heart of the issue and what these guidelines are intending to avoid, you know, the fact that someone is able to extract lower prices just because they can and just because they are bigger. You know, to answer the question directly, you know, I think that is the question exactly that I was posing, and it's that, you know, we can see instances where buyers would have a very unequal bargaining position vis-a-vis a certain supplier, for example, and they would have that. But that doesn't always necessarily translate into almost what I think about as market power, where you can dictate terms for the industry as a whole.
Sure. Thank you very much for that, Fatima. I think we are soon running out of time. So what we're going to do now is, I think, take very, very brief closing remarks from the panelists. You can be commenting on something that was raised by the other panelists that you didn't get a chance to comment on, but please be very brief, a minute, two maximum. What order shall we take? We'll start with Yongama, but before I say that, there are two other questions that we haven't gotten to from the attendees. So if you are, as the panelists, are in a position to answer that, please incorporate into your closing remarks. Yongama, any last words?
All right, just quickly. First of all, I think to the point that Derrick and Fatima were making, I think what these guidelines and the regulations are about, it's not so much about saying that you can't have a superior bargaining position. It is basically saying that you must be able to, it's almost like a transparency that is being brought in, be able to justify and explain. So your conduct is not just I'm powerful and therefore. There must be some thinking that goes into how firms conduct themselves in terms of their engagement between suppliers and sellers, and that's what is at the heart of the regulations. It's about justification. It's about transparency. You see this coming through also in the context of the EU regulations on digital markets, for an example. It's exactly the same concept. It's justification. It is not to say that you can't. You just must be able to justify. To Sha'ista's point, I think around the other levers or policy levers or tools of government, I absolutely agree. I think there is a broader conversation that is taking place in terms of digital platforms within government, and we will be publishing actually a strategy document quite soon on that, and absolutely agreed also in terms of the nexus between consumer protection and competition. I think we're quickly evolving into that world. And the last thing, Derrick, to your question around the 3%, the point there around it is that, so we're talking about 3% between like products, and it is to allow for some difference. But again, the key issue being about justification and not simply the fact that I have bargaining power and therefore I can conduct myself anyhow. Thanks. We can't hear you, Pam.
Thank you. I'm saying thank you, Yongama, for that input. Fatima, last words?
Perhaps I would just say, whilst we often think about this in terms of enforcement, I think a big driver behind this is the idea of driving behavioral change for large firms. Whereas previously it's quite, it could happen that large firms engage in this conduct, not necessary to harm or exclude, but just because they can. And so, what I think beyond the enforcement that we'll see, for me, what's quite interesting is how large firms now, or buyers, do react in trying to comply. And, as a community of practitioners around here, I think, it would be useful for us to understand how we can measure that, because what I think we want to see is almost this change, and as Yongama goes with this focus on thinking about a specific class of suppliers and ensuring that they aren't being disadvantaged just because of their size.
Sure, thanks Fatima. Derrick?
I'll just pick up very quickly on some of the points that Yongama, Sha'ista and Fatima said, and that just the interesting debate regarding digital markets and how impactful they've become, and that these debates aren't peculiar to South Africa. I think around the world, including in the US for that matter, the question is the old traditional consumer welfare test enough, and should we not be looking at incumbency, power, and the structural nature of markets and what their long-term consequences are. And then finally, I would just say, as I mentioned earlier, the best advice is you can no longer be agnostic if you're a significant purchaser or player within sectors regarding who you buy from and who you sell to. And you need, when you come up with the strategies, think about the policy imperatives which underline the Act, which are very specific, as the guidelines well articulate. They're there to address the imperatives attaching to SMEs as well as HDP firms. And thanks. I hope. Thank you very much.
Sure, Shayzon.
Okay, thanks. I think just to wrap up, I agree. When it comes to the consumer standard, it's something that's being debated around the world. I mean, you have the new sort of emerging debate coming out of the new Brandeis movement, or what's sort of times derogatorily termed hipster antitrust. So it's definitely not something that we're just talking about here, and it's something that I think has a lot of value in sort of just expanding our understanding of what welfare standard we're including and what sort of values we putting into our analysis of things. And then sort of more broadly, I think there's a lot of clarity that's come from some of the examples and the annexures of the buyer power guidelines, and well done to the Commission for doing that. I think my reservation still at this point is the anti-avoidance, and although the sort of provisions are there, I think I still have a nagging fear that it's going to be quite hard to actually police and try to show when someone is actually avoiding dealing with SMEs, because I think there are a lot of issues such as sort of quality or standards, and just in my interactions with some of the SMEs and HDIs that I've sort of worked on some of these issues with, I think it's going to be quite challenging to actually have the evidential base for this. But thank you for a stimulating discussion, everyone.
Sure, thank you very much. I'd like to thank the panelists for making the time to be part of this discussion. I think it's been very useful to get the different perspectives on these issues, and we'll be watching with keen interest as the Commission starts taking cases in this particular area. Just as a way of closing, we've got two very short poll questions that we're asking, and these should be coming up on your screen now. So if you can just answer, the first question is, the Commission's buyer power regulations and guidelines will go far in supporting SMEs in the designated sectors. It's a multiple choice question, so yes, no, or unsure. If you can please vote on that. And then the second question is about how useful this webinar has been. That feedback is very important because we are planning a number of webinars on similar topics within competition and broader industrial policy. So we want to know when we're hitting the right marks and when we are not doing so much. Okay, I think people are still voting, so I'll give that a minute. To the Commission, well done. The guidelines are quite detailed, and as some of the panelists have said, there are a number of things that can only be worked out once you do, the cases, and the answers will emerge as we have case precedents on a number of these issues. Okay, so we've got the results. I'm ending the poll and sharing results with everyone. Okay, so there you go, Commission. People think that 70% of the people in this session believe that the guidelines, the regulations and the provisions together with guidelines go a long way in supporting SMEs in designated sectors, and most people have found that the session has been either extremely useful or very useful, with a few saying only somewhat useful. Thank you very much, everyone. Please have a good evening, and we look forward to having you on our next webinar. Please look out on our social media and website for when we post about the session. That will be something.
Thank you, Pamela.
Bye.
Thank you. Bye.